Big ruling in the Supreme Court regarding a key provision of the landmark Voting Rights Act. They're saying that it cannot be enforced until Congress comes up with a new way of determining which states and localities require close federal monitoring of elections. Now, this has to do with Section 4 of the Voting Rights Act, and the justices said in a 5-4 ruling that Congress has to renew that Congress, regarding the recently renewed 2006 ruling, relies on 40-year-old data that does not reflect racial progress and changes in U.S. society. They did not strike down the advance approval requirement of the law that has been used, mainly in the South, to open up polling places to minority voters for nearly half a century since it was enacted in 1965. Now, here to talk to us a little bit more about what this means, Doug Uloth, a lawyer with more than 27 years of experience from Dallas, Texas, is going to talk to us about what this means and what all of the discussion is going to be about in the coming weeks. Doug, thank you so much for being here.
Thank you for having me.
So I know we were just talking about other Supreme Court issues, but the conversation has shifted yet again to another key issue, the Voting Rights Act. Were you surprised by this decision?
I think most people who've been watching the court were not surprised by the decision in the sense that the court has been telegraphing its concern about this aspect of the Voting Rights Act since at least a decision last year involving an Austin utility district that was seeking to address this issue. And they basically essentially said, Congress, you have a chance to fix this before we look at it again. And they felt like Congress didn't fix it.
I don't think many people are surprised about that. So when we're looking at this, they're talking about the different sections that they are concerned about versus sections that they're holding on to. Can you just explain briefly in layman's terms what section got struck down and what they're holding on to?
The court continued to some extent a trend of being as narrow as possible in its decisions, and it addresses two provisions of the Voting Rights Act of 1965. One of them establishes a formula, this is Section 4B of the Voting Rights Act, that decides what parts of the United States have problems historically with voting, minority voting issues. Section 5 of the Act says anybody who falls within the formula we set up in Section 4 has to go to the Justice Department or a court in the District of Columbia to ask permission to make any changes in their voting procedures, which include most prominently, I think, redistricting requests. So the court narrowly struck down the formula, but left the pre-clearance requirement in effect, saying, Congress, go write a new formula.
So with the upcoming major elections that we've got in 2014, are you anticipating that Congress will get on top of writing a new formula, or do you think that we're just going to be left with having to clear everything through all the states with any changes through the federal government?
Well, at this point in time, I'm not certain that there would be a basis for the pre-clearance request to continue since there is no formula. There can be arguably nobody subject to the pre-clearance requirement. So what we may see is states going forward with whatever types of changes they want to make in a big rush. And then if the law changes, the Justice Department will have to go back and look at what formula would cover, and they may end up seeking injunctive relief to undo some of the things that the states may do in the meantime. Alternatively, states may sit and wait, but I have a suspicion that the states will not do that. The ones that are wanting to make redistricting requests, particularly in my home state of Texas, are likely to go forward with doing what they want to do.
So when we're looking at this, we've got Section 4 that's officially been struck down, Section 5, which is kind of teetering on the brink. They still upheld Section 2, basically saying there is a need for some sort of oversight, but they're kind of leaning on Congress to decide what the best formula for that is. In the meantime, until Congress comes up with a formula, then what is a way to prevent some of the ridiculous gerrymandering that we've seen in some of these districts across some of the states?
Well, Section 2, as you noted, remains effective, and Section 2 is just a general broad prohibition against discrimination based on race, ethnicity, language, other traditional basis for discrimination regulation. So it could be possible that if states engage in gerrymandering of the type you're describing, that the court, the Justice Department may, under the guise of Section 2, come in and try to halt that from going forward. So I don't think that the government has lost all of the tools it might have to intervene in election structuring, but the game has changed for the moment, and the states would seem to have somewhat greater free reign. I mean, the decision is only 20 minutes old, so we haven't fully evaluated what it might do.
Well, pivoting just a second, I know that one of the things we were anticipating talking about today was rulings possibly on Proposition 8 and the Defense of Marriage Act. Now we're hearing that that's not going to come out today, possibly tomorrow. Is there a reason that you're thinking that they're holding off on issuing those rulings?
Although it may sound strange, the courts often struggle with getting the opinions right, so often complex issues wait till the last days of the session. And I suspect that the question may be there's some debate in the court amongst the members of the court as to whether they want to address the issues that are present in the Proposition 8 and Defense of Marriage cases, or whether they're going to do somewhat what they did in the prior cases last week in the Arizona Intertribal and yesterday on resolving them on a procedural ground. They may still themselves not be certain which direction those are going to go. I think they probably decided now, but they're trying to finalize the opinion, so they didn't do it today.
So we're still expecting Proposition 8 and Defense of Marriage Act. Any other landmark rulings that did not come out yet that you're waiting for?
I think that those are the two main ones that have been the focus of attention this term that haven't been ruled on. There remains the tiniest of possibilities that those could be carried over to the next term of the Supreme Court, and possibly the court might even ask for further argument.
Okay.
Speculation is that won't happen, but it's the tiniest possibility is out there.
Thank you so much, Doug. That's Doug Uloth, and he's a lawyer with almost 3 decades of experience in Dallas, Texas.